Mics are live, and I'm going to now admit, Lori, with your permission, I'm going to start admitting attendees.
Oh, sure. Go right ahead.
As attendees are piling in, I just want to remind everybody that MTLA will be submitting credit for today's seminar directly to the main board of overseers. It may take a day or two, but be patient, but we'll be doing that directly as opposed to doing certificates of attendance.
Recording in progress.
I just heard the youngest member of the bar, I think.
Yeah.
Give it just a couple more minutes, a couple more seconds.
You want to let people know to mute themselves? I'll do it. Oh, there we are. Okay. Folks, as you come in, if you could please mute yourselves. I guess Stephen is doing it.
Okay.
See ya.
Lori, we seem to have stabilized at 93 people admitted. If you want to go ahead and get started.
So,
Right. So I believe Steve's going to get us rolling, and then I'm going to offer some remarks right after Steve welcomes the breakfast group to this meeting.
So good morning, folks. I'm Steve Schwartz. I practice in Portland, and this is a Maine Trial Lawyers Association event seminar as well. And but we also have a Friday morning breakfast group that was started by Stan Tupper and was encouraged and carried forward by Peter DeTroy. And ultimately, when Stan took a sabbatical, I took on the reins of this, and we meet every Friday at Becky's, except for the first Friday of every month, which is on Zoom. We were on Zoom completely during the pandemic, and now today we're here. I don't know what we're going to do next week, whether we'll be at Becky's or whether we'll be back on Zoom again. But we're here to talk about the Maine Trial Lawyers survey on remote legal proceedings and to have a discussion. We're on to have a great panel today and to introduce, first of all, if you're interested in becoming on our mailing list, please just write to me, email me, sjs@schwartz-law.com, or call me up, and I'll be happy to add you to the list. We have about 300 people on our mailing list, and we have anybody from 1 to as many as 10 people on any given Friday, and sometimes a little more if we're on Zoom. Today we have over 90, and that's because of the good work of the Maine Trial Lawyers Association. So without further ado, I'd like to introduce the president of the Maine Trial Lawyers Association, Lori Boxer-Macomber. And Lori, I can only say, because having now 2 cases with her, and on the other side of one and kind of on the same side and kind of not on the other, she is formidable. She is thorough, smart as a whip, and we're honored to have her join us and lead this discussion today.
Well, thank you, Steve. none of those compliments really are due. But in any event, thank you to everyone for showing up on a Friday morning in the middle of the summer and supporting the MTLA through your interest in our programming. We are a nonprofit organization and we rely on the wonderful work that our executive director, Steve Prince, does for us, as well as on the volunteer work of our board and executive committee. And so while we offer free programming like this, because we think it's important to make it accessible to all members of the bar, regardless of whether they're members of the MTLA, we really appreciate those of you who support our organization and have joined it and are working with us on our committee work and other work, or who have volunteered to speak at our programs as well. And I also want to thank our distinguished panel members, Judge Duddy and Justice Murphy and Jason Jabbar, who are going to speak to us today about the survey. And Jason's going to give an overview of the results, as well as what's going on internally in the courts and the considerations that we as members of the bar need to keep in mind as we evaluate whether remote proceedings are working in our practices, and as we push for or reject the use of them both directly and as hybrid proceedings. So that is our roadmap. We're gonna start with Jason providing the overview of the survey and then head to the panelists. The impetus for this survey, just to give you a little background, was the comments that were made by Acting Chief Justice Mead during our March annual meeting. He said it would be very helpful to hear from members of the bar about how these proceedings were working for them. And so our executive committee of the Maine Trial Lawyers Association, which consists of Susan Fonts, Jason, me, Chris Lewis, and Lisa Lunn, decided to put together a brief survey. We wanted to put together something that people could do in a relatively short period of time, and that would offer us a taste for what people were experiencing. So we put together that survey, and then we talked to our board about whether we wanted to solely distribute it to the MTLA or whether we wanted to get it out there to everyone else. And we ultimately went with the latter option because we thought it was really important for the court, not just to hear from people who do primarily plaintiffs' work, but to hear from people who practice in all areas of law. So that is what we did. And I'm going to now turn it over to Jason, who will talk about what we found.
Happy Friday morning to everybody out there. My name is Jason Jabbar, and I'm a lawyer primarily representing plaintiffs in civil matters. I work at Jabbar Liberty in Waterville. We also have an office in Portland. And I'm privileged to serve on the Maine Trial Lawyers Association, the Board of Governors. We do a lot of good work, as Lori alluded to. Part of that was conducting this survey. There's no question that during the pandemic, we were forced to make changes that some of these changes made our practices more efficient. So the question as we move forward is, which of those changes do we take into our everyday practice as things start to return to normal, and which of the traditional things do we try to return to? And this survey results, I'm going to share with you. I'm going to go through them as quickly as possible as to not put you into a slumber, but we have a PowerPoint that I'm going to share and go through with some of the some of the interesting results of the survey. So this was about lawyering in the era of the Zoom boom, MTLA survey that was conducted. It was completed in June. And so, Steve, can you see that? Okay.
Yes.
Okay. So we had 98 responses to our survey, and to give you an idea as to the areas of practice of the respondents, we had 54% of them identified themselves as plaintiff attorneys, 18% identified themselves as defense, 16 represented both plaintiffs and defendants, and 12% total represented other. family law, state agencies. So we had a wide range of attorneys answering the survey. As to the experience that our respondents had handling remote proceedings, as you can see, 48% of the respondents had more than 20 remote proceedings that they had handled. 23% had participated in 10 to 20 remote proceedings, and 22% 6 to 10. So we had a good range of experience with these respondents. We asked how satisfied people were in general with their participation in remote proceedings. The ratings went from 1, which was poor, to 4, excellent. And it's interesting to see that the ratings on the different things that we do. So depositions, the rating was 3.1, ADR 3.3, hearings 2.8, conferences 3.2, trials 2.2, law court proceedings 2.6. And this represented the total group. We also evaluated the plaintiff heavy subgroup, and the results were almost identical. So as you can see, the ratings for ADR and depositions were good. We're definitely lower for trials. Some of the themes that we heard consistently, the advantages were cost savings for client and the attorney, reduced travel, out-of-state witnesses can be deposed with ease, convenience for clients, lawyers, and adjusters, particularly with mediation, no waiting in courts to be called for hearings. And this was especially the case for criminal and family law. I don't handle a lot of criminal cases now, but I can speak personally to the experience of waiting in court for 2 hours, sometimes more, just to stand up for 30 seconds and say, tell the judge what the status was. So this is an efficiency that many people recognized in terms of status conferences and dispositional conferences, those sort of things. Being able to do it remotely made their practices more efficient. Disadvantages that we saw. Some people had complaints about depositions. Some were struggling with questioning opponents about documents and screen sharing. Some struggled with internet connection and technology issues. We had some comments about the inability to assess body language and the nuances associated with in-person depositions. It was more difficult for some people to connect with parties or adjusters at mediation. And there was a recognized lack of in-person gravitas where it was not suitable for trials. One of the comments on that, it was interesting. There were different perspectives, particularly with the depositions and the issue of questioning witnesses about documents. One of the comments was, it remains a challenge to have a witness mark on an exhibit or interact with an exhibit. Another person said, there's no question exhibits are more difficult to handle on Zoom versus in person. Now, on the other hand, there were people who found it easier to question witnesses about documents. One comment was, I find it easier to have witnesses mark up documents digitally because it's done on screen and counsel can see what witnesses are doing in real time instead of having to peer over a conference table. So some of the different comments were interesting, but there was a theme of certain people having a hard time with questioning witnesses about documents over Zoom. So as to the question, is this here to stay? 62% of the respondents want to use remote depositions in half or more of their cases moving forward, and 69% would opt for remote ADR in half or more of their cases as we move forward. Respondents were asked about the future of Zoom depositions. The question posed, once the court's emergency order presuming the use of remote depositions sunsets, will you want to continue to take depositions via Zoom or other remote means? 34% said majority of the time, 28% said half the time, 29% occasionally, and 9% said never. This represented the total group, and the results of the plaintiff-heavy subset was almost identical. As to the future of Zoom ADR, the question, how often do you anticipate that you and your clients will voluntarily opt for remote mediations, arbitrations, and judicial settlement conferences? This represented these numbers represent the total group. A majority of them said, or 40% said a majority of the time that they will opt for remote ADR. 29% said half the time, 28% said occasionally, and 3% said never. With the plaintiff heavy subset, it was slightly different. 43% said majority of the time, 24% said half the time, 33% occasionally, and 0% said never. 2/3 of the respondents want presumed remote proceedings to remain in place for a while. 19% do not want the orders to remain in place, and that number was slightly higher in the plaintiff-heavy subgroup. The future of remote proceedings. The question was, due to ongoing uncertainties regarding COVID-19 and health and safety concerns, I'd like to see the court orders on presumed remote proceedings in certain contexts remain in place until at least January 1 of 2022. And this is the total group. 33% strongly agreed, 32% agreed, 15% were neutral, 10% disagreed, and 9% strongly disagreed. So 55% of the respondents agreed in some way that they'd like to see the court orders on presumed remote proceedings remain in place until January 1 of next year. 4 out of the 5 respondents believe remote proceedings make practice more efficient and save clients money. And the results were comparable between the total group and the plaintiff-heavy subgroup. The statement was, Zoom and other remote proceedings allow me to practice law more efficiently. And as you can see from the results, 83% agreed with that statement. Zoom and other remote proceedings save my clients money. And over 80%, 83% agreed with that statement. So it was clear that people felt that the changes that were forced upon us by using Zoom, particularly with ADR and certain depositions, made their practices more efficient in some ways and saved their clients money. The plaintiff-heavy subset, the results were similar in this, where 80% agreed. As you can see, the numbers there. Some extracted comments on cost savings from the survey. One was, Zoom and other remote proceedings are the only reason we can take on some clients who would not otherwise be able to afford our services. If Zoom mediations don't resolve the case, where's the savings? That was one particular example. There were many other comments that spoke to the benefits and the efficiencies of having Zoom ADR. One of the other themes that we saw was, as long as the person running the mediation had a knowledge and a mastery of technology and breakout rooms, there wasn't a problem. If that wasn't the case, then there were problems. Family law status and pretrial conferences rarely require in-person participation. These should be done remotely by default. Travel to court for in-person participation is a poor use of the client's resources and results in time spent unproductively by attorneys. That's sort of the experience I mentioned at the outset, where I stand up and I call the docket or a dispositional conference in a criminal matter, stand up for 30 seconds after being there for 2 hours and my client's paying for my time. This definitely is more efficient. My clients can reduce the amount of time they take off from work, time needing childcare, et cetera, when appearing remotely for routine court conferences and even mediation. So, people spoke to not only the efficiencies for them, but for their clients. A majority of the respondents do not have significant problems sharing exhibits in remote proceedings. Some did. 1 in 4 of the total group reported problems. Almost 2/3 of the plaintiff-heavy subgroup reported no significant problems. So with respect to technology issues, presenting, reading, reviewing, and answering questions about exhibits is generally not a problem for attorneys, parties, and witnesses at Zoom depositions, mediations, arbitrations, hearings, and other remote proceedings. As to that statement, 18% strongly agreed, 34% agreed, 22% were neutral, 22% disagreed, and 3% strongly disagreed. So more than half of the respondents agreed with it, but there were a fair amount of people who disagreed with it or who were neutral. The plaintiff-heavy subset was a little more in favor, as you can see. 22% strongly agree, 39% agree, and less disagreed or were neutral. Most wanted in-person bench trials and jury trials to resume as soon as possible. 1/3 want hearings and law court proceedings to return in person as soon as possible. About 10% of the respondents want depositions, ADR, and discovery to return in person as soon as possible. As to the statement, I would like to see the court return to primarily holding in-person proceedings in these types of proceedings as soon as possible. Depositions, 11%, ADR, 13%, hearings, 31%, discovery, 3%, bench trials, 58%, jury trials, not surprisingly, 81%, and law court hearings, 31%. So there was clearly a greater desire to continue with depositions in ADR, or maybe I should say a greater tolerance to continue with depositions in ADR remotely versus bench trials and jury trials. This represented the total group. The plaintiff-heavy subgroup results were almost identical. Certain comments to resuming in person. Discovery conferences or quick pretrial status conferences are okay by Zoom, saving an hour or so. Travel for a 10-minute hearing or conference is preferred. I strongly support the use of Zoom for jury selection for in-person jury trials. And this is an issue I expect that the panel will be discussing today in terms of the possibility of using Zoom as we move forward for jury selection, even when we're having jury trials with brick and mortar. So the big question that it leaves us with, and this is something that an important discussion that the panel will have today is what do we do now? How do we move forward? We're going to talk about remote status, case management, pretrial conferences, mediations, ADR, judicial settlement conferences. Do we continue remotely, or do we try to get back to in-person mediation? I've talked to mediators about this, and the mediators I've talked to who have got used to using the technology and mastery of the breakout rooms now appreciate being able to conduct mediations remotely and feel like the quality of the process and the ability to resolve cases has not been compromised. Remote depositions, will they continue? Remote jury selection, as I discussed. What about bench and jury trials? Will we have different standards? Will there be a higher tolerance for doing bench trials remotely versus jury trials, which obviously are more difficult? And e-filing, that's been started as a pilot project in certain counties. I think it'll be interesting to discuss how that's been going and whether that's going to be, or how quickly that's going to be adopted elsewhere. Electronic notarization hasn't been discussed, but was something that was incorporated due to the pandemic. That was a convenience for lawyers who needed to have their clients to notarize documents for their clients without their clients having to show up in person. And so, and these are important issues, and the survey certainly spoke to that. And I look forward to hearing, the panel discussion today as we discuss how we incorporate some of these practices as we move forward. So I thank you for the opportunity to present this survey results, and I'll go back to Lori for the panel.
Great. So as you were speaking, Jason, there was one question in the chat room, and we welcome questions in the chat room, or if folks want to chime in and ask questions, we're going to allow that to a certain extent as we move forward with the judicial panel. But the question that was raised was a question about whether there was any variation in the survey participants' rankings, the way they said that they supported, moving forward with remote depositions or whatever else it may be, based on the number of remote proceedings that particular survey participant participated in during the pandemic. And my initial response to that, and I'll let others who worked on compiling the data chime in as well, but I think that our goal in finding out how many remote proceedings people had participated in was a general goal to make sure that people who were answering this survey actually had a fair amount of experience, because we didn't want to be basing our results on people who hadn't even done a remote deposition, criticizing the process if they hadn't actually experienced it. So when we took the temperature of who was taking our survey, that was the purpose of doing that. And I don't believe that we broke down the rankings to the level that the person asking this question is asking about. Although Steve, if you did, certainly let us know, or Rich, if you're on, Rich Reagan worked with Steve on compiling the data.
I don't think we did. I think it's something that we can do. But one of the early questions that I went over, it was clear that the people who responded substantively did have experience. I think it was 48% of the people had more than 20 remote proceedings that they had participated in. And it went from 6 to 10 to between 10 to 20. The vast majority of the respondents had, I think, at least 10, or at the very least, at least 6 experiences with remote proceedings. So
Right.
we did not get the feeling that people were chiming in on issues that they didn't have experience dealing with.
Right. And I think the other thing we were looking for was to see if we could find agreement among members of the bar, regardless of whether they were plaintiff heavy or defense heavy. And we were pleased to see that people are generally experiencing these proceedings the same way, regardless of their practice focus. And so the goal here, I think, for us as the trial lawyers is to work with all members of the bar on helping the court to come up with procedures that work for us all, as opposed to having different constituencies advocating or discouraging certain things. We really want to work together to see whether some of these things are done informally in the future or formally through rule changes or orders or whatever, and see if we can have as much consensus as possible when making recommendations to the ultimate decision makers. So that was, part of our goal there too, is see how far apart or how close together we all were as a bar. Listening to the survey, one of the things that came up today that I'd like the judicial panelists to speak to is we've been hearing about how attorneys who have, resources and education and working in these proceedings have been handling the proceedings and how their clients have been responding. But I'm also curious. I see Liz Stout and others in the audience that work with people that don't necessarily have counsel. How is this going with respect to pro se parties, and what can we as members of the bar be doing to help out the court with respect to that? I mean, is the court seeing that this is harder for certain populations, or is it seeing that it's working fine, even if people aren't represented? And if it's not working, okay, are there opportunities or areas where you see us coming in to help or assist, even if it's on a limited basis, with making sure that everyone has access to these types of proceedings? So Mike, do you want to start with, I'm sorry, Judge Duddy? I have the problem of having been Mike's former partner and calling him Mike. Judge Duddy?
As they say, call me anything you like, just not late for dinner. Well, I don't know if you want me to speak to that specific question about can the bar help out pro se's or not, or just generally?
Generally, I mean, it's up to you to respond as appropriate.
First off, let me just note, I think as I look at the participant list, my colleague Judge Chuck Dow is there as well, and I hope he will feel like he can and should speak up from the judicial perspective as well as we go along. So I think most judges and justices have been incredibly interested in looking at these survey results, because on this side of the bench, we also have been asking and observing the level of interest from the bar in continuing to build some component of remote proceedings into what we do. And so first, I would say these results are very helpful. As a general proposition, think that they reflect a lot of support for continued use of remote proceedings in the categories for which there's substantial support. I find that just very helpful to know about. What I hope to be able to see moving forward after this year and into future years is that the trial judge will have a lot of discretion to craft the proceedings as the lawyers and parties want and need, so that if lawyers want certain things to happen remotely, they simply can. And if they don't, we can bring them in and have in-person proceedings, and the judge can be the tiebreaker if there's a mix. Or you can simply have hybrid proceedings. I mean, early on in the various pandemic management orders, judicial officers were discouraged from allowing hybrid proceedings. That was quickly reversed because it just made manifest good sense to allow hybrid proceedings in certain situations, not in everything, but certainly in certain situations. But I think as a larger point, what made sense was to allow the judge, in working with the attorneys and the parties, to customize everything, the use of technology, whether it's Zoom, phone, coming in person, whatever is necessary to move the case along in the way that's most efficient and most comfortable for the lawyers. I think many or most judges are at this point extremely comfortable with the technology as well, and welcome the bar's request to do things by Zoom or phone. I think it adds a lot of efficiency to what we do on this side of the bench as well. And what I also will say is that it has been, for me, as a fact finder, almost superior in some respects in terms of observing witness demeanor than having somebody in person live in the courthouse. I thoroughly love seeing witnesses testifying from their organic environment versus the artificiality of in a courtroom. And all of the clues that surround that witness, I observe how seriously they've taken the proceeding in terms of their own setup, how they dress, how they comport themselves. Judicial officers have different views about how strict we are in telling witnesses, you can't be smoking, you can't be doing this, you can't be doing that. My personal approach is I'm going to pretty much let the witness show me who they are doing whatever it is they're doing, because that speaks incredibly loudly to me. And for attorneys out there, I think it's incredibly important for you, if you want to prep your witnesses to make good impressions, to understand that your jobs are harder now that they might be testifying outside of your presence from their home. And every single thing that they're doing goes into the mix in terms of my viewing their credibility and persuasiveness. And I think it's more helpful than seeing them in person. I'm perfectly prepared to do bench trials remotely if necessary, probably more so than the lawyers are. I think screen sharing and document use remotely is pretty seamless for folks who have done it once or twice, so they get past the initial fear of doing it. So I think we can do a ton of work remotely. My only, well, not my only concern, but my big concern over time is the trade-off between efficiency and culture. The practice of law is more than pushing dockets. And the craft of judging is more than pushing paper. We're all in this together. You're all officers of the court. The practice of law requires community. It requires socialization. It requires seeing people in person and renewing bonds. And I just fear that over time we'll lose that. I think Zoom and remote works pretty well now because, as I'm sure Justice Murphy will say as well, I know so many of you, either from private practice or from being on the bench now. And so when I'm on a remote proceeding, I just feel like I already know you. And there's sort of not much lost in translation. But the longer we do this remote stuff, I think the harder that becomes. Anyway, I'll turn it over to Justice Murphy.
Good morning, everybody. Well, I guess I have a few caveats to append to what Judge Duddy had to say. I have an overall preference for in-person proceedings, but I am also a scheduling judge, which means I'm in charge along with Judge Davis in Region 4 to schedule events, both criminal and civil. And certainly a lot of the things, the concerns that have been driving our decisions involve the health and safety of our staff, including the marshals, the clerks, the judges, the litigants, and the public who come in. You've all been reading what's been going on out there with the pandemic. And what I hear consistently from court personnel is they are exhausted with all the going back and forth. I'm sure that's not just the court system that's feeling that way. I'm sure your law offices have those same kinds of experiences and concerns. We throw language around like hybrid proceedings. Those are I think Judge Duddy is certainly one of the best judges as far as being able to be comfortable with those sorts of technological challenges. I don't think that's true of all of our jurists. And the clerks are really struggling to keep up with this concept of, well, let's leave it to the particular judge to decide how the proceeding is going to go. Let's leave it to the scheduling judges to decide what we're doing in criminal versus civil. And so I would just implore all of you to remember that we are really having a hard time. And I don't think that's just in Kennebec. I think that's statewide. We have a real marshal shortage. That's a real problem. That would make it, it would suggest that maybe we should consider doing more remote proceedings. But the scheduling, the rescheduling, the unscheduling, the scheduling again of events has been very difficult for everybody. And I'm certain it's been difficult for all of you as well. We would like to get back to in-person. That's the direction that we all want to move in. But I think we have got to get to the point where we're not just exploring remote proceedings. I think we have to be prepared to pivot to remote proceedings for certain identified events, including jury selection, at least for civil cases. Obviously, jury selection has been the bottleneck for getting the jury system back up and running for both criminal and civil. Civil, as always, has taken a back seat to the criminal jury process. But I think we have to look seriously at doing civil jury selection by Zoom. Justice Horton, who was not able to be here today, and I participated in a working group with civil practitioners to try to figure out if that was a viable option to do civil jury selection. We modeled, or we actually talked to people in King County, Washington, Seattle, and they, back in, I guess it was July of 2020, the Washington Supreme Court just dropped an order and said, the jury system's going forward in criminal and civil, and it's all going to be by Zoom. And there was no working groups, there was no deliberation, they just ordered it to happen. And so people had to adapt. It's my understanding that that is continuing with civil jury trials, certainly with civil jury selection. And I think what we're hearing from people out there is that things are going pretty well. I just think we have to make a commitment that for certain dockets, that we're going to be prepared to go to to remote proceedings, or maybe presumptively continue remote proceedings. Certainly what Jason said about status conferences, arraignments, those sorts of proceedings that really just take a few minutes. If we can guarantee connectivity for pro ses and even for lawyers who don't live right in town, I think we just have to be seriously considering doing those presumptively remotely. I am hearing, on the other hand, from my colleagues who do settlement conferences, they don't always like to do them by remotely. Judge Duddy, you do a lot more of those than I do, but what I hear is, the phrase "skin in the game" is used a lot, and they want people to be face to face. That, I think, that's coming from the judges. I certainly hear what the bar is saying about that, but my colleagues, at least the ones that I am in touch with, say that they would prefer to do those things in person. One of the things that we are going to be doing this October at the Judicial College is discussing with the Superior Court training for doing some civil jury selection by Zoom. I think there is probably a fair amount of resistance on the part of some of my colleagues about the concept. We all, would like to go back to the way things were. I don't know that that is going to happen in the next few years. I think we're going to have to start looking at things differently we have to get the jury system back on its feet. As all of you know, we have not been doing civil jury trials at all. I have 2 cases that were called in for August as backup to criminal, but we just never know if there's going to be time to pick a civil jury. And that's pretty hard for civil practitioners, I think, to not know whether or not their case is going to go or not. I know that was done in the past where civil was always backup to criminal jury selection. But I think we tried to go away from that before the pandemic struck. But the only thing that I know to do in order to get the civil jury system back on its feet is to seriously consider picking juries by Zoom. And that could run sort of as a parallel track for the criminal jury selection, which I think is going to have to continue to be in person no matter what the pandemic does to us. But I don't know how long we can wait. I mean, it's almost, we're coming up on 2 years without civil jury trials in Maine. And now we're just talking about training judges on how to do it. So realistically, I just think we have to get serious about identifying the dockets that we're going to presumptively do by Zoom, and stick with that for the sake of the clerk's offices, if nothing else. I love the idea of letting, and I think Judge Duddy and I can do this in the business court. We do a lot of customization for lawyers about how do you want to do this trial, that sort of thing. And we're able to do it because, we have experienced practitioners generally, we have great clerks, but we have a limited number of cases as well. That's not a luxury that most judges have, whether it's in FM dockets, PC dockets. We have to take those judges have to take all customers. So we have to identify the dockets where it works, identify the dockets where it doesn't work, and I think stick with those sorts of plans, because it's just really, really hard on everybody to go back and forth. And I hear that every day from the clerks, from the marshals, and from the lawyers, and particularly the criminal bar. who now have to do things differently in Penobscot than they're doing it in Portland or doing it in Augusta. And it's just causing a lot of stress for a lot of people.
So thank you for those initial comments. Before we got started, Justice Murphy, you were talking about a pilot program potentially being started in York County for doing remote selection. Do you know when that might actually happen?
Well, actually, what I think the SJC has just approved, and Justice Horton was going to be able to talk about this, although I did see Justice Jabber's name pop up here, and he may be able to make sure that I say this correctly. But from talking to Justice Horton, it's my understanding the SJC has approved for York County beginning to summons jurors, sending out questionnaires to jurors, everything being done online. In other words, there's no mail. There would be a data set for the jurors. It would be secure and confidential. And it's my understanding that the way that information would be provided to the bar would be that the information the court receives would be printed out and provided to counsel and parties. The rules about not contacting jurors and that sort of thing, and not sharing the confidential information in the questionnaires would still be in place, but the court would be able to communicate with jurors electronically. And that has actually been done successfully in criminal jury selection, which we sort of just did as we figured things out in the beginning of the pandemic. We started doing a lot of things with jurors online, questionnaires online, and that sort of thing. But the rules about lawyers not being able to access that information or share that information, outside of their offices or with a small subgroup of people would still be in place. But that may not sound like much, but I think it's a big step for the court system to consider doing that, and the SJC has approved doing that in York County. Julie Howard, who is the court manager down there, has been very creative, and she's one of these people that asks forgiveness and not permission, which a lot of us have been doing throughout the pandemic. She was instrumental in getting the Violations Bureau up and running by Zoom. She was instrumental in doing a lot of walk-in arraignments, what we called walk-in arraignments by Zoom. And I think that sort of creativity is helpful. But again, what we need to do is to, I think, from my point of view as a scheduling judge, try to provide some stability and predictability for the bar and the court staff as to which ones we're going to be doing which way, and which ones we're going to continue to do in person. But that's starting right up, I understand, in York County. I think Justice Horton and I, as part of the working group, I think we were both really skeptical about jury selection by Zoom. But I have to tell you, after doing sort of a mock jury selection, we tried it a couple times. I am a big now believer in that. I think Justice Horton is as well. We think it has real benefits. Judge Duddy very eloquently described, you can really talk to a juror like this. It's much more effective and meaningful to be able to look at someone's face, to hear them clearly. I mean, when we bring in 100 jurors into a courtroom, we're squinting at them, we're straining to hear them. They can't hear us, but they're much more relaxed if they're at their office or at their home. And you can really engage with them in a way that I didn't think was possible. So certainly for civil jury selection, I think it really has possibilities to be maybe not a permanent, but perhaps a permanent fixture of our system. And I don't know how else we're going to be able to resume civil jury trials unless we take a bold step in that direction and just get going with it. And we have to get the SJC to agree with that. We have to get the Superior Court to agree with that. I think if people can see what it's like, and like I said, I was a real skeptic, but now I definitely think it's very beneficial in many respects.
So
Justice-
if I'm hearing you all correctly, there's going to be some type of judicial continuing legal education going on sometime within the next half year where people might be exposed to
Right.
that type of thing, and maybe rethink where they stand on it.
Right, and we have to get the SJC obviously to bless this. But so I'm hoping within the next few months, we'll be able to try it in real life with a real group of jurors. The only other alternative is to keep the civil jury cases as backup to criminal. And as everybody knows, we have a significant criminal backlog. And I just don't see that happening because of the exigencies of the criminal system are so different. And civil will always take a backseat to that.
Justice Murphy,
Yeah.
have you learned anything to that point that you were talking about with jury selection and what you learned through the mock process? Have you learned anything from Washington or other states who have embarked on remote jury selection in terms of ability to connect with jurors being more candid than they would typically be in front of 100 others, and with respect to juror satisfaction, you know, in terms of being able to do it in their home versus going and dealing with the parking and sitting around all day with
Right.
people?
They provided us with a survey that I'm talking about Seattle. And it was federal court doing it in partnership with the state court. They rolled it out together basically at the same time. There was a juror satisfaction survey, and it was overall very positive. The jurors like the fact that they don't have to leave, their home and travel. I mean, that's a huge problem in Maine. Connectivity, however, is also a problem in Maine. Seattle does not have that kind of challenge, as you might imagine. It's probably one of the most sophisticated parts of the country in that regard. But at the same time, travel. I mean, we have jurors who travel from Jackman to Skowhegan to do jury selection, and that is a huge burden on them. And so they were very relieved to be able to stay home or stay at their jobs for a morning, and it was really easy to hear and to see them. They were very relaxed, and this, as I said, the survey was overall very positive. There were a few jurors who had done it both ways, who had jury experience, in person versus remotely. And you have to understand, they're doing their entire trial that way. They're not just doing selection.
Mm-hmm.
And one thing that I remember the jurors saying, the ones who had been deliberating by Zoom, the ones who had done it both ways preferred to do that in person. They thought something was missing. But I guess I just want to emphasize, the only thing anybody is talking about in Maine right now for jury work is jury selection. The working group, I think, was unanimous that we still want to bring juries into the courthouses once they're selected and do trials in person. And we have the capacity to do that safely with COVID. We've been doing trials throughout. The district court's been doing lots of trials, all child protective proceedings, I believe, and PFAs. A lot of them have been conducted in person. Mike, you can tell me if I'm wrong about that. But you and I, Judge Duddy and I, have done bench trials throughout the pandemic. So we can do trials safely during a pandemic, but we can't do jury selection safely during a pandemic without a ton of work and a lot of delays.
The ability to evaluate a juror online brings into mind what Judge Duddy said about, he said in some ways feels it's easier to evaluate the credibility of a witness, which also leads me to a comment in the survey, which was from an attorney who said that the adjuster felt that it was easier to evaluate the plaintiff in the Zoom mediation than in person. And I didn't, I'd like to hear the elaboration on that, but that was a comment that we had in the survey. It's interesting.
Right. Oh, go ahead.
Judicial settlement conferences, quite a number of them by Zoom. And there's some of that same spillover, Jason, that is, you sometimes can engage quite well via Zoom with somebody, especially in the breakout rooms. And Zoom is proven, I think, for certain types of cases to be really preferable for the JSC format. For Justice Murphy, for instance, I do a lot of the asbestos case settlements now, and there are people all over the country. But the issues are so well known and so well trod in those cases that Zoom works really well. with some of the really tangled business cases with lots of interpersonal dynamics going on and so on and so forth, the Zoom JSC does not work as well. So it really depends on the proceeding. But I'm sure that adjuster is correct, because I sometimes feel the same thing. I can learn more from somebody by video, ironically and shockingly, than I can seem to in person.
So I was going to go back to the comments about, it looking like it's going to take a while to really get civil jury trials back on track. And I'm interested in hearing from the court on things that are being done to address that in other ways. Like, so is there talk about making discovery conferences more accessible to civil litigants, or increasing the number of judicial settlement conferences and judicial settlement conference judges, or any other effort to supplement this or to address the problem of us not getting to civil jury trials earlier or on time?
Well, Justice Murphy may, from the Superior Court,
Yeah.
be well positioned for that.
We're just starting to resume civil dockets in the Superior Court. I mean, the Superior Court was told at the beginning of the pandemic that we were going to be primarily doing criminal. And that was our charge. That has now changed. We are now able to schedule civil months again, but that doesn't mean we're not doing a lot of criminal as well. But we do a lot, there's a lot of aspects to the civil docket. There's oral arguments, there's 26G conferences, bench trials, summary judgments, all the like. So I think it's just going to take time. And I'm not sure that we can wait another 2 years. And it could take that long if we just keep doing what we're doing, back and forth, back and forth. But we are scheduling civil dockets. We certainly are doing oral arguments by Zoom. We're doing bench trials by Zoom or through a hybrid method. But as long as we have this really daunting criminal backlog, the pressures I think that we all feel are making that harder. And depending on where you are in the state, civil dockets aren't taking place in some places at all.
One of the things that, I don't know if anybody is feeling the need to address it or not, but there are a lot of civil cases filed pre-pandemic in which plaintiffs made a jury request and paid the jury fee. Defendants didn't, but under the rules now, the plaintiff can't withdraw that request for a jury without agreement of the parties. And now they're basically, even if they want a bench trial, because they don't want to wait 2 more years to get to a jury trial, they're being held hostage by that rule. And they can't sort of reverse direction at this point.
Right.
And I just don't know whether that merits some further consideration or not. But that's another reason why there are many civil cases parked hard and not moving.
So that would be a rule change that the Civil Rules Committee would consider? Is that what you're
Well, it would
suggesting?
require a rule change, but I just don't know whether there's any appetite for it. But it's just an observation that I make.
Speaking of rule changes, are there any rule changes that the court is aware of, or any proposed rule changes or talk about rule changes that would make it easier or harder for us to proceed with remote proceedings if there are disagreements among counsel?
Justice Murphy, I don't know if you have some insight into that. My guess is any such rule changes are going to wait till after our judicial conference later in the fall, and we, as a judiciary, can talk it through a bit more. But I don't know if there's anything else in the offing.
We've been doing a lot of things during the pandemic that violate various rules. And that's just a fact. We certainly have done that on the criminal side. And events keep overtaking us in terms of trying to get the rules squared away with what we're actually doing. This was the next Monday was the week we were going to resume all in-person proceedings in Region 4 for criminal, which meant everybody was coming in for everything. And now you can imagine what people are thinking about. Now, what do? Do we shift back to doing a lot more by remote means for criminal? It takes weeks for things to get unscheduled and rescheduled as far as the clerks go. So I'm thinking about the rules all the time, but really the way we have been getting through the pandemic is we've just been doing the best we can. And we've been trying to follow the spirit of the rules, but a lot of the rules have been ignored because we had no other choice, especially for criminal matters.
Would the two of you be able to speak to some of the practices that you've seen attorneys using that work really well for moving their cases forward? Obviously, when people can do things by agreement, that works really well. But things that have worked well that you've seen them doing, things that are not productive, for example, if they're calling the court or the clerks too much or whatever it may be, what's going on internally with respect to perceiving how we as a bar or members of the bar are reacting to these changed times, and what can we be doing better? What should we be aware of? What's happening on the ground there that we might not know about?
Well, I've seen in the comments coming through a number of folks saying, well, gee whiz, there are connectivity problems, there's problems with video quality and so on and so forth. And those comments are all accurate. So for the lawyers, it seemed to be, I think, really helpfully and successfully navigating these difficult times. They somehow find the time prior to a proceeding to work with their client to troubleshoot in advance those issues and not wait until their client's having a hard time seeing, or they can't work their mute button, or so on and so forth. I mean, I can tell that there are attorneys who have taken their clients through dry runs, or really worked with their clients on the technology, the connectivity, ensured their client is driven to the IGA parking lot or something, wherever they get good connection in advance. And that's incredibly helpful because it is accurate that there are all of these problems, but by and large, all of these problems are solvable. It takes a little bit of effort and a little bit of thinking ahead. Now, having said that, I understand the burdens right now in the bar and attorneys are tremendous. And so it's hard to find the time to do that. And I'm not trying to criticize anybody who isn't because of the time demands, but that certainly does help a proceeding when the lawyers have worked with their witnesses and parties sufficiently in advance to anticipate and solve those problems. It just makes everything run more smoothly. Now, I will tell you that there are lawyers who are very frustrated with their colleagues who haven't done that. And then the proceeding gets hung up and they're justifiably frustrated.
Anything to add to that, Justice Murphy?
No, I just, please be nice to the clerks and the marshals. They're really having a hard time. And I know everybody in your offices probably are having their own struggles with everything, but they're under tremendous pressure, and it's just the going back and forth has been very difficult for everybody. One of the things that was interesting to me was that during the pandemic, we had electronic filing, which I thought was terrific. Judge Duddy and I have been doing a poor man's e-filing system in the business court for many years, which we still think works better than Odyssey, but in any event, the clerks, the problem, one of the things I'm not sure the bar realizes, the clerks were fine with accepting electronic filings, but they also had to accept paper filings. So they were getting double filings. And that was really a dumb idea. And then what happened is they asked the clerks, well, what do you want to do now that we're opening up? And they said, we just want to go back to paper because we can't do both. The bar, I think, wanted to continue with electronic filing. At least that's what I was hearing from people. But the rules right now is, I think we're all back to, by and large, we're doing mainly paper filings again. There are a few exceptions to that. But one of the things I think would make a lot of sense is if we had a uniform statewide policy of accepting electronic filings, even outside of Odyssey, before Odyssey rolls out, which could take years. But I think people are ready for that. I think the bar is ready for that. I think the clerk's offices are ready for that, but they just can't handle both. And during the pandemic, they had to deal with both, which really just made their lives harder. I would love to see that happen statewide. But it can't be both. It has to be one or the other.
Justice Murphy, just to get back to one of the points and to kind of put a bow on it. One of the overriding themes of the survey comments was we need to get back to civil jury trials. And I think, correct me if I'm wrong, I think what you're saying is if we can adopt a remote jury selection process, that we would be able to get back to civil jury trials quicker than otherwise. Is that a fair?
I don't think anybody knows, but right now we're not doing anything. And the working group talked about this a lot. Should we just go back to having civil jury selection as backup to criminal? And that may be viable in certain parts of the state that don't have a lot of criminal selection. So you bring a pool and you pick the criminal you have to, and then you pick civil. Remote counties have been doing that forever. In the big courthouses where the backlogs are, just by virtue of the sheer numbers, are just crushing, I don't see that happening. As I said, I've got a couple civil juries that are on backup for August. I don't know that they're going to get reached. I won't know until the day of. So perhaps we need to do both, schedule them as backup where we can. But I mean, how long can we wait?
As a practical matter, how do we get there? I mean, what's it going to look like to get there?
Well, I think the SJC, first of all, has to bless it. They have to give us the OIT personnel to help us smooth out the rough edges, which exist. But, you know, other states have done it much more quickly than we have, mainly because we haven't decided that's what we're going to do. And if we decide to do it and commit the resources to it and get the judges, and just the judges have to be told this is what we are doing, even if it's not your preference. I mean, sometimes judges have to be told that as well, because we just really have to start doing those trials, at least exposing the cases for trial. And no one is taking any of that seriously right now because there's nothing scheduled. Right. So, but we do need, there are some things that we have to do, but they're all doable. I think, as Judge Duddy said, there are problems, but they are very solvable. We just have to have the will to do it, and the decision has to be made, and we just have to start. At least that's my feeling.
Thank you.
I think I'm not sure if we're going to be wrapping up soon, but I certainly want to thank everybody for participating in this and allowing our breakfast to be a little bit of a part of it. I'm just going to say anecdotally, it's been absolutely terrific to be able to do pre-trial matters in what I do, mostly criminal cases, via Zoom, that I could be in Somerset County in the morning, in Biddeford in the afternoon, and get for even a Rule 11 hearing in Skowhegan, for example, anything non-testimonial. Was certainly a blessing to be able to do that. And I get to pass that savings on to my clients. I think it's an access to justice issue. I think we're already talking about shortages in rural areas in this state. And while I don't mind driving and have driven to Washington County, certainly it makes it easier if the pretrial matters, at least, we don't have to drive to them. I can recall driving 4 times to Bangor for a docket call in one DUI case a couple of years back. No complaints about that, but obviously it's much easier if we don't have to do it that way. So Violations Bureau case is another perfect example of how it can work really well. The clerks are fantastic at this. And they provide breakout rooms. I think courts providing breakout rooms can be extremely helpful in any situation if somebody is about to, talk settlement or something like that. So hopefully that at least for my 2 cents, I hope that that will continue, just as I hope that testimonial hearings by and large could take place in the courthouse. We did about 6 PFA trials during the course of the pandemic, and they worked very well. And even with people being masked in each one of them. So, I hope that something can be learned from the survey that was done. And we'll say, I guess the jury is out on how jury selection will work. But thank you, folks, and thank you, Lori and the MTLA, for what you did for this proceeding today.
And with that, I think that we'll do right now, unless Justice Murphy or Judge Duddy have any final comments, we'll go ahead and wrap this seminar up and thank everyone for attending. So is there anything further that you would like to share with the audience today, Judge Duddy or Justice Murphy?
I just want to say a big thank you to the bar. This is, as I mentioned earlier, a collective effort, and by and large, I think actually without exception, counsel have been terrific in trying to work through this period of great uncertainty and change. It's frustrating for all of us, but I want to thank everybody for their flexibility and willingness to adapt.
Thank you, everybody.
Well, thank you everyone for attending, and we look forward to seeing you at our future MTLA events.
Thanks, everyone.
Bye-bye.